Good afternoon, everybody. Welcome to another employment law question and answer session. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin. I'm working out of our Ottawa office, but I practice throughout all of Ontario. I am here once again to answer all of your questions relating to employment law, workplace issues, you name it, I'm here to answer it. Whether it be a question about severance pay, termination issues, changes to your terms and conditions of employment, any types of other issues in the workplace, most commonly that we're hearing these days related to COVID, vaccination questions, of course, because that is currently the hottest topic in employment law when it comes to COVID-19. So any questions at all that you may have or that you may have on behalf of a friend or a family member, please don't hesitate to send it in. I'm here for the next 30 minutes, and I'm more than happy to answer all of your questions as they relate to anything employment or workplace law. So please send them in, and we'll answer all of your questions. I have a few things that I was going to talk about today if we had time. But I see here that I'm already starting to get a question. So I'll get to the question that we have right now, and we'll go from there. So everybody who's watching now, send in your questions. We're already getting a few coming in, and we'll get to as many questions as we possibly can this afternoon. So I have a question from April on Facebook who says, I've been with my employer for 3 years and have been on medical leave on short-term disability for the past 3 months due to stress from the workplace. About 3 weeks ago, my employer sent me the paperwork to apply for long-term disability. I found a new job and looking to quit my current job to start at the new organization. Do I need to provide 2 weeks' notice? I also hear that it is not a good idea to quit while on long-term disability. Does this also apply to me since I'm on short-term disability? All right, April. So very, very loaded question. Lots to unpack here, and I'm happy to do that with you. So if you found another job, and this is a question that I actually get pretty often when it comes to quitting a job and going to, a new job, accepting new employment and moving to your new position. So oftentimes, if you've signed an employment contract with the current employer, and that could be a one-page letter of offer, that's an employment contract, or it could be a more formal multiple-page contract, regardless of the format. If you've signed something regarding the terms and conditions of your employment, and if you've been with your current employer, April, for the last 3 years, the odds are you probably did sign something, but you might not have. So if you did sign something, that will dictate potentially what amount of notice you have to give if you're going to resign. So usually you go to the contract, any employee, if you've signed a contract, look at the contract, see what it says. More often than not, if it does address resignation, it usually will say that you need to provide somewhere between 2 to 4 weeks of notice. The standard is 2 weeks. Now, aside from the contract, if you've never signed a contract, if your contract is silent when it comes to resignation or how much notice you have to give, then there really is no legal obligation to give notice when it comes to a standard. So, as we know on the employer side, if somebody is terminated, there's a minimum amount of notice or severance pay that needs to be provided to the employee. But for the reverse situation, the law doesn't actually prescribe a specific amount of notice that has to be given unless the parties come to an agreement in writing, for example. Now, what I often advise my clients is if you're in a situation where you don't have anything written in a contract, so there is no actual legal obligation, you would still be wise to provide some notice in order to make sure that you're leaving on as good terms as you possibly can. There's also arguably an obligation at common law, meaning it's not written anywhere that you have to do this, but it's generally a common practice and a good idea to provide adequate notice. This is especially so when you're in a management position. So there actually is case law out there, decisions that have come out of the courts, where somebody who's in a very high up position, a very senior manager, decides to just, up and quit without any notice whatsoever, walk out the door and leave. And the challenge in cases like that is that person is causing damage to the company potentially by not giving enough notice, because there's a transition that needs to take place. Sometimes there are transactions that are pending. And so in situations where you have a very high senior management position and you have a lot on your plate and a lot of responsibilities, even though there is potentially no contract in place that says you have to give a certain amount of notice, the law does provide for the fact that a certain amount of notice should be given in order to ensure that you're not damaging the company or the employer by leaving without notice. So that kind of covers the gambit in all different scenarios. If you're not a higher up, a higher level employee, if you're an entry level employee and you're not, mid transition or in the middle of anything that would cause damage to the company, technically you could leave without notice. But again, from a practical perspective, I always recommend giving some notice in order to ensure that you don't burn any bridges moving forward. So I hope that answers your question, April, with respect to how much notice you have to give, depending on the circumstances, which will always change the answer. Now, when it comes to the disability leave, so, disability benefits are separate from employment. So you can actually take a medical leave and not receive disability benefits, because it usually is through a separate provider and through a separate analysis. So currently you're on medical leave from your employer, and when somebody is sick or has a medical condition that prevents them from working, that person goes on medical leave. Now, what determines whether that leave is paid or not is not necessarily the employer. It's whether there's disability benefits in place that you can apply for and whether you're eligible to receive those disability benefits. So those are two kind of separate legal issues. And when it comes to the disability leave, you would have to be unable to work in order to continue to get benefits. So if you're in a situation like April, where your doctor may deem you to be able to work, if you're accepting new employment and moving to a new job, then there is a date in the very near future at which your doctor thinks you'd be able to work. That means that you will be cut off your disability benefits, regardless of quitting your job, because if you're able to work, you're not going to be eligible for disability benefits. So in terms of your last question here, April, that it's not a good idea to quit while you're on long-term disability, it's just a question of your medical ability. So if you're not able to work, then you should be continuing to stay on your disability benefits and not working. As if you are able to work and your doctor has cleared you to be able to work, and you're going to a new job, necessarily you'll have to quit your current job and move to the new job. But at any time when you're on disability benefits, if your doctor clears you to return to work and you're able to work, you won't be eligible to receive those benefits anymore. So I hope, like I said before, I hope that clears it up. It's a bit of a loaded situation for you, April, but you absolutely, are in a situation where you're not stuck, and you certainly can move forward with the plan that you have in action here. I would just recommend some sort of notice to cover your bases. The other thing that I'll add is, if you're currently on medical leave anyway, there isn't likely any obligation for you to give notice there, because you're not at work currently. So there cannot be transactions or any sort of items that are pending or outstanding that are your responsibility, because you're not at work. So that greatly reduces any possible damage that you can cause to the employer by not returning to work and not giving them working notice of your resignation. Have another question coming in here. So I have a question from somebody on YouTube who asks, why would an employer be obligated to give an employee anything more than minimum severance? Great question. So this is a question that we get pretty often. And what's really important to understand, whether you're an employee or an employer, is that there are two systems that govern severance pay. There's the written law that's created by the government, which is under the Employment Standards Act in Ontario. Every province has a similar piece of legislation. It's employment standards legislation. In Ontario, it's called the Employment Standards Act. And that's the law that governs the minimum amount that any employee is entitled to receive when they are let go without cause, which is the vast majority of regular terminations. And under the Employment Standards Act, there are obligations to provide two different things depending on the circumstances. There is working notice or notice of termination, or pay in lieu of notice of termination, which we often refer to as termination pay or severance pay. Now, that amount is about 1 week per year, depending on how many years of service you have, but it averages out to 1 week per year of service, up to a maximum of 8 weeks for 8 years. That's one element under the Employment Standards Act, which is the bare minimum of what an employer needs to give an employee upon termination without cause. The other element under the Employment Standards Act, and this is where a lot of people have misconceptions, is called statutory severance pay. That amount is only owed in certain situations, and the vast majority of cases where statutory severance pay would be owed are situations where the employee being terminated has over 5 years of service and the employer's payroll is over $2.5 million per year. If those conditions are met, and there are other conditions that can be met, but just for the purposes of your question, we'll talk about this only, then an extra 1 week per year of service is owed to the employee as well. So you have those two elements under the Employment Standards Act that would be owed to an employee no matter what on a without cause termination. There's no release that needs to be signed. Nothing needs to be signed. It's a non-negotiable minimum. The other system for severance pay is called common law. And that's what's governed by the courts, by the decisions and by the judgments that come out of the courts. And that is the default. So if somebody doesn't have anything in place as an employee that limits termination entitlements, you're automatically owed your full severance at common law. So the bare minimum under the Employment Standards Act is just that. It's a bare minimum. It's a starting off point, but it's not the limit. The default is the full severance, and that's what's owed by default unless there's another arrangement in place. And so when we're talking about severance, usually what we're talking about is your common law full severance entitlements as an employee, which is based off things like your age, your length of service, your position, and so on and so forth, in order to estimate what potentially the severance owed in a particular set of circumstances could be. And for those entitlements, that's where our firm has a free severance calculator, where if you are simply curious about your termination entitlements, or you think you might be let go, or you have been let go, you can go to our severance pay calculator. It's at severancepaycalculator.com. You can input your information, and that will give you an idea of what you could possibly be entitled to receive as your severance. So in terms of your question, the question that came from YouTube, why would an employer be obligated? The way the law works is that the default is more than the bare minimum unless the parties have agreed otherwise. So in most cases that we see, an employer will start off by giving the bare minimum, and an employee may think that you're not entitled to more than that. But in 9 out of 10 cases, and sometimes even more than that, as an employee, you certainly are owed more than the bare minimum, which is where we come in and try to assist people in getting what they're owed. I have more questions coming in here from Fortress Maximus on YouTube. I see there's a few questions, a couple questions here. So the question is, in what situation can an employer ask for an independent medical examination? I am off work due to mental health and physical issues. They are giving me 24 hours to sign consent forms to disclose medical information to them, as well as my physician. Okay, so what you're talking about here is a couple different things. In situations where an employee goes off on medical leave, if for some reason an employer does not believe the medical documentation that you provide, then they do have the ability to question it by asking for an independent medical examination, but it's only in very limited circumstances. And it's especially in situations where, for example, somebody has been off work for a lengthy period and the employer wants to basically ensure that the employee isn't able to return to work in any capacity at that point in time. That's usually the purpose. The other purpose, like I mentioned, that we don't see as often, but we do see sometimes, is if there's an issue at the initial onset of the medical leave where the employer wants to get more information. So at the onset of the medical leave, if an employer wants to get more information, they are entitled to certain information, but some information is and can remain private. So it's really important to discuss your situation with an employment lawyer, because the context of your medical leave, your position, your medical condition, your employment terms and conditions, all of those things will impact the legal situation and the advice that we would give you. So I'd say for now, get in touch with us. You can contact us. You can contact me directly. You can go to email us at help@employmentlawyer.ca. The email is on the screen right there for you. Otherwise, you can go to employmentlawyer.ca and look up my contact information and contact me directly so that we can get more details about your situation. Because as I mentioned before, generally an employer does have a right to request these things and to ask for disclosure of certain things, but the right is limited. It's not a free-for-all in terms of an employer being able to send you for all sorts of different examinations and being able to access years of medical records. That's not the right that they have. They do have a right to a certain amount of information, but there is a limit. In terms of the deadline they provided you, 24 hours, that's ridiculous. There's no such thing. There's no law that says you have to disclose it within or sign a consent form within 24 hours. To me, that sounds like a pressure tactic. So definitely don't feel pressured by that. You have time to make sure that you consult with an employment lawyer and get the legal advice that you need so that you can make an informed decision on whether or not you're going to give them the information that they're asking for and submit to the independent medical examination. So you definitely want to be getting a comprehensive advice from an employment lawyer on this particular issue. Just getting to another question here. I have a question from Jamie on Facebook who says, I'm currently on disability at work, but will have to go back soon. I have not declared my status nor had to comply with any testing, etc. Obviously, they'll want to know my status before returning. What is the best way to go about this and try and gain severance pay, at least before being put on unpaid leave? I work at a university. Staff association. Thanks. So it's not clear, Jamie, if you're unionized. If there's an association, you likely are unionized. And if you're unionized, you need to speak with your union. We've been contacted by a lot of people over the last few months who are unionized, dealing with these vaccination mandates. And unfortunately, we're unable to assist people who are unionized. We can always give advice, but we can't actually directly assist you because it has to go through the union or the association that you're a member of. So if that's the case, Jamie, you should definitely contact your union reps right away to see if you can get assistance from your union on this issue. If you're not unionized, in terms of vaccination mandates, so if there is no government mandate or actual law that has been put in place by the government that requires vaccination, so if there is no mandate in place that requires vaccination in the industry in which you work, then you are owed severance if you are put on an unpaid leave or if you are terminated for cause. So an unpaid leave is something that you don't have to accept. If you're being put on an unpaid leave for failure to be vaccinated in an industry where there is no government mandate, then you can treat that as a termination of your employment and you can pursue severance. Similarly, if you're terminated for cause and not offered any severance pay, you can pursue your severance in that situation as well. So if your employer is requesting that you provide proof of vaccination prior to returning from your medical leave, you simply can't provide that if you're not vaccinated, then you should simply let them know. respectfully, cordially, politely let them know that you're not vaccinated. And if you have no intention of becoming vaccinated, you should also let them know that, because some employers are giving an extra 2 weeks or an extra 4 weeks to give you the time to reconsider your decision or become vaccinated. If you know right away that that's not going to change and you're not going to be getting vaccinated, then let them know that right away, again, respectfully, and then you'll see what they'll do. You can't prevent them from putting you on an unpaid leave. You cannot prevent them from terminating your employment, but you can pursue your severance after that occurs. And so if that does occur, Jamie, if you're suspended without pay or put on an unpaid leave, or terminated for cause, get in touch with us and we're more than happy to help you pursue your severance. So I have a question here from YouTube, Su Chang, who says, I am in a key executive position of a company in the president role, and I'm also the majority shareholder and director in a family business, but not involved in the day-to-day operations. Are there any complications with my current employer? Could there be? So in terms of your question, there might need to be clarification here, but if there's no conflict of interest between the family business and the company for which you work, in other words, if they're in completely separate industries, different sectors, they're not competitors, there's no conflict there, legally speaking, that should be fine. The only potential challenge you may have in terms of there being any issues is if you've been asked to, or you have already signed something that wherein you agree to exclusively devote your time to the company for which you work. I've been seeing something like this in a lot of employment contracts lately, where it's a clause in a contract, and the title would be something like exclusivity. And it would be a paragraph that says that you agree that you will devote all of your work time to the company, to your employer, that you won't work for any other company. So if you've signed something like that, there could be a potential issue there. If you haven't signed anything of that nature and there wasn't an agreement of any kind that you couldn't do other work on the side, and again, there's no conflict, you should be fine. There shouldn't be any issues, generally speaking. And if you are being asked to sign something of the nature I've described, or you already have, sometimes what happens is an employer will put that in a contract because they want to avoid any conflicts of interest coming up, and they don't want people to be spending time on something else during regular work hours. But if you're in a situation where you're working for your family business, but it's not during work hours, you're barely doing work, there's no conflict, it's, you've worked there for a very long time and it's just, to have your hand in the family business, that's something that you should disclose to the employer and say, here's what's going on the side. It's not an issue, but I wanted to let you know because if you want me to sign this exclusivity clause, we just need to be on the same page that this is going on the side. And as long as they are aware of it and they say that's fine, then you can go ahead and sign something like that as long as you have their agreement in writing. So that's something that we've seen in the last few months that's become a little bit more prominent than it has been in recent years. It seems to be coming up more frequently, and it's likely because so many businesses have shifted to remote work, either a hybrid remote workplace or a completely remote workplace. And that does, in theory, allow people to have more than one job, more time on their hands, less supervision from the employer. So from the employer's end, I think there's more concern there as we transition into more of a remote workplace. So I think we're going to see more and more of this coming up, but that doesn't mean that it necessarily would prevent you from continuing to do something that you were already doing, as long as there's no conflict there. So I'm just getting to a few more questions here. I have a question from the Dreamer on YouTube. If the employer is going to limit one's severance entitlements in an employment agreement, how specific excuse me, how specific does the language of the agreement have to be? Does it have to be simple, easy to understand? In short, yes, it does have to be easy to understand. It can't be ambiguous. It has to be very clear. And there is a very specific language that needs to be in the contract that would limit it. So more often than not, the language that's used, if you do have a contract in place that you've signed and there is a termination clause, more often than not, it will be unenforceable for one reason or another because the proper language was not used. There needs to be perfect language used in a termination clause in order for it to be applicable and actually limit termination entitlements. And sometimes it just comes down to one word being the wrong word used, or one word that's missing, or a little bit of ambiguity, or something is excluded when it shouldn't be. You know, the list goes on and on and on. But there needs to be very specific language used in order to limit termination entitlements, which is why the vast majority of contracts are not actually enforceable in limiting termination entitlements. So I have another question here from Jamie on Facebook who says, my wife works at a hotel and has been put on temporary layoff until February 25th. They called yesterday to ask her to provide her status and she needs to reply by early next week. What is the best way to try and gain severance in this situation? So it's similar to the question that you had asked previously, Jamie, in the sense that there is nothing that can be done to ensure that you can pursue severance. From a legal perspective, if there is no government mandate in place, and there isn't for hotels, then the employee has the ability to pursue severance by treating an unpaid leave or a temporary layoff. Those are interchangeable terms, so it could be a temporary layoff or an unpaid leave. You can treat that as a termination and go after your severance. And if you are terminated for cause, you can also go after your severance. So in terms of providing her status, if she either doesn't want to provide her status with respect to vaccination, or she advises them that she's not vaccinated, assuming that that's the case, Jamie, which is probably why you're asking this question, then she should answer the question as she feels comfortable, and then they may terminate for cause, at which point she can pursue severance, and they may continue her unpaid leave. Now, based on your question, she's been put on an unpaid leave or temporary layoff until February 25th. I don't know when she was initially put on the temporary layoff or the unpaid leave, but certainly, she doesn't have to wait around until February 25th. She could take action now and pursue severance based on her unpaid leave. So if your wife is interested in that, Jamie, definitely have her get in touch with any of the lawyers at our firm. She can email help@employmentlawyer.ca, or again, you can go to employmentlawyer.ca and look up my contact information and contact me directly there. I'd be happy to help you any way that I can. And that goes for anybody that's watching. So we're just at the end of our time for today, but if I didn't get to your question, feel free to email us separately. Like I said, the email is help@employmentlawyer.ca. You can contact any of our lawyers by going to our website at employmentlawyer.ca and contacting any of us there. All of our contact information is there, and you can get in touch that way. We also have another live question and answer session on Monday at 1 o'clock. So if you wanted to ask your question live, that's the next time to do it. If not, we have other sessions next week as well. So thank you everyone for your questions today, and I hope that everyone has a great weekend.